Hey, welcome back. And for those of you who are watching on a video, a couple more clues as to where in the world I might be. In this little section of the lecture, I want to talk about lawyers' duties to the client. Now, starting week 6 or 7 from memory, we are going to we'll spend 2 weeks deeply engaged in what the lawyer's duties to clients are. But right now, what I want to do is really bring together the overview of what the duties are with some of the questions that we've been talking about when it comes to technology. So you'll remember from our very first class, or if you don't, I'm going to remind you, that we talked about the hierarchy of duties. And even though we're going to spend a lot of time on duties to the client, and even though a lot of the case law that we're going to look at and the rules focus on the duty to the client, when we think about the hierarchy of duties, essentially the duties that lawyers have to the court and to the administration of justice, to obeying the law, are all actually fundamentally more important than the duties to the client. This can stick with us a little bit from time to time because we do naturally focus, regardless of the ethical preferences that we have, on looking after the person that we are engaged or retained to look after. And this is really fundamental to remember that one of the ways that we can do this, whether it's as a zealous advocate or whether we are looking at through a rights framework, is because our obligations to defend our clients, to advocate for our clients, to negotiate on their behalf, are tempered by these broader obligations to the court and to obey the law. One of the things that's worth remembering is that when you get admitted, and you need to be admitted to practice before you can hold a practicing certificate and practice law, is at that point you become an officer of the court. And so your first duty will be to the court. But that doesn't necessarily in any way diminish the strength of the obligations you have to your clients. So in broad term, what are your obligations to the clients? The language tends to be characterized by words like loyalty, party and partisanship. You can tell when I start to read, can't you? Partisanship, acting in the client's best interest. We talk about the duty to the client as being fiduciary in nature. So not all of our duties to our clients are fiduciary, but many of them are. And that means that we have an obligation to put our clients' interests ahead of our own. And more than that, not to profit from our interactions with our clients, even if our client isn't harmed in any way by us taking advantage of the relationship that we have with them. Now, while we have fiduciary obligations to our clients, we also have commercial obligations to them. The fiduciary obligations we have don't preclude us from charging money for our services. And so the contract that we have with our clients, we refer to them as retainer arrangements. So the client retains the lawyer to advise them. But retainer is just another word for contract at the end of the day. And so as a consequence of the contract that we have obligations under that contract. Retainers will specifically set out some of those obligations. Some of the things that are contained in retainer arrangements are prescribed by the relevant rules, and others arise essentially in the same way of any contract, as lawyers and law firms over time identify where the risks are and essentially codify the basis on which they are prepared to enter into arrangements with their clients. Often a key element of the retainer will be, almost always, will be the amount that is charged. Traditionally, lawyers charge by the hour, or in 6 or 10 or 15-minute increments. So in other words, they record their time and they charge for that time. One of the things you might have noticed in the Jenny Pakula article that you were asked to read is that she is acknowledging what many of us think is the elephant in the room here, that whilst lawyers charge by time, there is little or no incentive for them to find ways to do their work more efficiently, or to invest in equipment or technologies that would ultimately reduce the time that it takes to do legal work. Now, this is a somewhat cynical view, but it's a view that is prevalent, and it's a difficult question to consider in some ways because, as Richard Susskind once said in a speech, it's very difficult to convince a room full of millionaires that their business model is failing. But there is no doubt that as disruptive technologies come up and as we see alternatives to using the legal system become more and more available to small and medium-sized businesses, to people who are having disputes with neighbours or online vendors, or people who just want to document their affairs, who are looking at products or technologies such as LegalZoom or LawPath or other tools that will allow them to assemble and create their own legal documents. That's an example of those disruptive technologies that we spoke about recently. Well, I think they will be, where the products and services that are being offered as alternatives at the moment are quite likely vastly inferior to going to a high-end law firm and dealing with the single greatest specialist in section blah 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 of the Stamp Duties of New South Wales Act, or in the context of family law disputes or whatever the particular high-end bespoke issue is that you need to address. But for many users of the legal system, we need to remember that they don't actually want to use the legal system. What they want to do is solve their problem. And they don't have a legal problem, they have a problem that has a legal element to it. So let me crawl back to where I started. This is where PowerPoints are quite useful, I guess, is that when we have a contract that deals with how we're going to get paid, and the provisions that deal with payment refer to measuring the amount of time that it takes and then paying by the hour or so, there's an enormous change piece involved in changing the way that we value and sell legal services, as well as the way that we conduct ourselves in providing those legal services. So many academics will argue that there is a duty, because we have a duty to act in the best interests of our client, there is always going to be a duty to find the most time-effective way to do that. That doesn't mean that we always have to charge by time and that we have to find ways to continually invest to reduce cost. I mean, as a business proposition, if it costs us more to produce the services, then people are going to be leaving the profession in droves. Now, that's not to say, and I'm sure there are plenty of you who are not thinking about how much money you're going to make when you go into the profession at this point in time, and quite frankly, nor should you be. I think it's all about, personally, I think it's all about finding ways to make a life and let making a living take care of itself. But I say that from a position of privilege, absolutely. I say that from a provision of being a commercial and M&A lawyer for a long time and, making a fairly decent wicket out of it, to be perfectly frank. But that doesn't mean that the driver is the money. And if we can find more effective and efficient ways to do the work, to ultimately charge less for it, to be able to do more meaningful, useful, and intellectually stimulating work, I see that as being a good thing. It's, it's really dealing with our duties to ourselves as humans, which, by the way, don't fall within the legal ethical framework in any way. So a couple of things that come out of this. Firstly, we have duties to work as effectively as we can and as efficiently as we can if we see those things as being relevant to acting in the best interests of our client. We need to recognize that the way we charge for our fees can be a disincentive to finding ways to do the work more effectively, and that there is a significant change piece that we're going to need to see in the profession in order to address that. And this is something that I think most law firms are grappling with quite significantly at the moment, is how do we charge for our services in a way that represents the value that our services bring, and that provides sufficient incentive to continue to invest in the development of high-end legal services. The last part of the duty to the client that I want to really focus on, though, is the duty of loyalty, the obligation to keep a client's secrets, if you will. They're two closely related duties here. We'll spend a lot of time further on both of them in detail, but I want to think about how they work in practice with technology at the moment. So let's think about confidentiality and legal privilege. So often we have a contractual duty to maintain our clients' confidences. It's something that is quite regularly inserted into our legal contract. And at the same time, there is no doubt that lawyers have a duty under the relevant professional law rules and as a matter of general law to maintain our clients' secrets. So Rule 9 of the Australian Solicitors Conduct Rules, these are reflected also in the Uniform Rules and in the Barristers' Rules as well, says that a solicitor must not disclose any information which is confidential to a client and acquired by the solicitor during the client's engagement without proper authorisation. So 3 parts to the test. If there is a disclosure, is it client confidential information? Has it been acquired during the solicitor's engagement? And is there proper authorisation? If all 3, we need the first 2 for there to be a potential breach. If there is proper authorisation, then it's not a breach, but without proper authorisation, there will be. So this is great, okay? It's pretty straightforward, seems pretty clear. But these rules were largely developed in a time and an age where the way that confidential information could be disclosed was either by the leak, inadvertent or on purpose, of a written document, or the solicitor saying something that they shouldn't say. These days, when we're talking about the use of AI over large pieces of data, we no longer have the limitations of the human memory. If there are millions of pieces of paper relevant to the way that a business works and operates, a single lawyer is not going to be able to read them all, much less find patterns that can really impact the meaning of that material. So in a large M&A transaction today, or in a large piece of litigation, we're seeing technology-aided review, technology-assisted review, TAR, which we've spoken about a bit. And so data rooms like Ansarada or Law and Order's discovery models, they are looking in very short periods of time over very, very large pieces of data. And they're able to recognize patterns in that data that relate to the acquisition or to the dispute, but they can also recognize patterns that relate to all sorts of other things. So it's going to be really important as the use of these tools evolves for significantly more informed consent to the use of the tools and the mining of that data. One of the things I'd really like you to do, because I think this will make this point better than I can in words, is I want you to go and find your profile on the search engine that you use, particularly if you still use Google Chrome or Bing or Explorer, something like that. Google is particularly good at working out stuff about you. It doesn't necessarily need your consent to see your personal information in order to work out roughly how old you are, what gender you are, what your political leanings might be. It can amass this information by looking at patterns. Now, the algorithm that is probably best at doing this is TikTok. I'm too scared to go on TikTok because of this, really. But I know many of you will have been. And what it's doing, one of the things that apparently makes TikTok so addictive, is that the algorithm is really good at working out what you've watched and what else you might like because of that thing that you have watched. Now, so what? Who cares? TikTok is for entertainment. But when you think of the power of those kind of algorithms and the types of information that lawyers get access to as a consequence of the fiduciary relationship, the trusted advisor relationship that we have with our clients, there is significant opportunity for AI that we control and administer to see patterns that we otherwise might not, or to augment our understanding of the ways that our clients work in ways that we might not. Many lawyers develop expertise in particular industries, so they're often working on different unrelated matters, but across the health industry or the logistics industry or the travel industry, whatever it is that's interesting to them. Now, as a consequence of that, they have multiple clients who are competitors of each other. And so one of the things that we need to be thinking about is the way that we maintain information barriers, how we separate out information and data that is useful to all our clients from the information and data that is proprietary and owned by only one or two of them. When we're thinking about data too, gone are the days that we're only really thinking about written word and the things that we have in our memory. There have been huge advances in voice technologies over the last little while. Some of you will have noticed that I try and download a transcript of my lectures each time. I'm having those automatically generated using some GPT-3 AI, so voice, natural language processing, artificial intelligence algorithms that basically take my recording and put an okay sort of transcript in place. Like, it's not perfect, I'm not proofreading them, but I know that they will be helpful to you, and they're also helpful from the point of view of finding things and making sure that I have actually talked to you about the things that I need to talk to you about. Previously, and it's still the case, a large part of the way that lawyers recorded information that's given to them by clients is in file notes. But we can record information and search across voice so much more easily these days. So, well, why wouldn't we, if it's in the best interests of our client to do so? Well, I can think of a whole heap of reasons why we might not want to, given that the data could be used for a whole range of purposes, not just the purpose that we've given our lawyers access to it for. But at the same time, we need to balance out, well, what would a reasonable person do in these circumstances? What's to stop somebody who is recording information by taking notes from applying their own bias in some way and not recognizing the most important things, or giving undue weight to something that shouldn't be important? These are really interesting questions, I think, and stuff that I'd really like you to be thinking about as you head into the next assignment. And I'm going to talk to you a little bit about that in the next video. Cheers.